advocacy experience, both oral and written, is at the core of the QC application process. QC status isn't awarded for excellence as a lawyer in general. It's specifically awarded for excellence in advocacy in the higher courts of England and Wales. Advocacy work encompasses any written or oral submission that persuades a court, tribunal, or arbitrator to rule in your client's favor. Not all solicitors routinely do advocacy work. Realistically, if you aren't an advocate, it won't be worth your time applying for QC. The QC selection panel is looking for evidence that you can advance a client's case through your advocacy work by identifying the best course of action, communicating it persuasively, and rapidly responding to and integrating new evidence into your arguments. If you have extensive evidence of this, and you're an outstanding practitioner in your field with experience of complex cases in higher courts or in arbitrations, you may already be eligible to apply. If not, you are not ready yet and will need to gain more experience. The first thing to note is that this won't be a quick process. To be considered for appointment by the QCA, you must start gaining experience many years in advance. While advocacy is not part of everyday work for most solicitors, those solicitors who do specialize in advocacy in complex cases successfully applied for QC status. The key is taking advantage of any opportunities to undertake contested advocacy work. This can mean dealing with advocacy yourself in a case rather than instructing a barrister. Some applicants have found pro bono work to be a helpful way to gain the experience they need, as it allows them to take on a more active courtroom role. It's important to also remember that your individual contribution to a case is more important for the QC application process than the complexity of the case itself. It's much better to be able to demonstrate relatively short advocacy on a complex matter than extensive routine advocacy. Complex advocacy can be defined as advocacy for which a QC might reasonably have been instructed. If your advocacy experience has only been against junior advocates, there would be a question as to whether you are at the right level yet. On the other hand, if you have appeared in court alone against a QC, this experience would be helpful in demonstrating the level of complexity and substance you are capable of with your advocacy work. If you're not there yet, spend time planning your career and proactively seek advocacy opportunities so you're ready to apply in future. For more guidance on applying for QC, go to lawsociety.org.uk/QC.